Well, Committee on Oversight and Government Reform will come to order. As a reminder, pursuant to Committee Rule 5B and House Rule 11-2H4, the Chair announces he may postpone further proceedings today on any question of approving any measure or matter or adopting an amendment on which a recorded vote of the yeas and nays are ordered. And without objection, the Chair is authorized to declare a recess at any time. This is a continuation of the business meeting we started this morning. Prior to the recessing, we were considering the Lynch Amendment to H.R. 1364, and we had heard from Mr. Lynch, Mr. Heist, Ms. Plaskett, and Mr. Clay on the matter. We will now resume discussion of that amendment. Does any other member wish to speak on Mr. Lynch's amendment to H.R. 1364? If none, the question is now on the amendment offered by the gentleman from Massachusetts, Mr. Lynch. All those in favor signify by saying aye. Those opposed, no. No.
Mr. Chairman, I request a recorded vote.
A roll call vote has been requested. As previously announced, further proceedings on the question will be postponed. Mr. Raskin, did you care to be recognized?
Thank you very much, Mr. Chair. I've got an amendment at the desk.
Clerk will designate the amendment.
Amendment to H.R. 1364, offered by Mr. Raskin of Maryland.
Without objection, the amendment is considered as read, and the gentleman from Maryland is recognized for 5 minutes to explain his amendment.
Thank you very kindly, Mr. Chair. If the clerk would kindly bring me a copy of the amendment too. Thank you much. This is very much in the spirit of the prior amendments, just to refresh everybody's recollection. The underlying legislation would dramatically disadvantage the ability of employees to act in a union representative capacity on so-called official time. And this has been a mainstay of labor management relations within the federal context for decades now. All of us agree that people should not be conducting union business during office hours, such as conducting union elections or campaigning for union office. All of that's already against the law. On our side, we don't really see the purpose of this legislation, and we want to make sure that it doesn't impinge upon essential First Amendment activities. So the sum and substance of my amendment, Mr. Chairman, is to say that it would not be swept within the scope of this new legislation. Any time spent identifying, preventing, or addressing conflict of interest issues in the agency, this shall not be considered official time. So we want to be very clear about that. We're living in a time of great ethical ambiguity, to say the least, in the nation's capital. To take one example that has raised the public eyebrow, the President of the United States is one of the owners, he may be the sole owner, of the Trump Hotel, which has a lease with the federal government, the General Services Administration. And that puts the President of the United States in the odd position of being both the landlord, because he appoints the director of the GSA, and also the tenant, because he owns the Trump Hotel, or at least some very substantial majority part of the Trump Hotel. Now, there happens to be a separate provision in the lease which prevents any elected official in the United States or the District of Columbia from deriving any revenue from the lease. So it looks like there's a direct contractual violation. But set that aside for the moment, because the President has decided to go forward. If an employee of the GSA were to, say, write a memorandum saying that he or she believed that the Trump Hotel was in violation of the lease, and that person were punished for it or somehow retaliated against, and other employees tried to defend the person, and those people were punished or retaliated against in the scenario that we've seen so many times before in this committee, we would want to make certain that the representatives of the employees could step forward to say that there's a dramatic conflict of interest taking place within the agency, and that this would not come back to haunt them either in terms of their own employment contracts and benefits or in terms of other kinds of adverse employment action that might be indicated and implicitly validated by this new legislation. So all we're doing in this amendment, and again, it's a very small carve-out from sweeping legislation that we don't think we need, but obviously we take the good sponsors at their word that the purpose of this legislation is not to undermine conflict of interest protections for workers and conflict of interest provisions that guarantee public integrity. And so this simply makes it clear that conflict of interest issues being dealt with by a representative is not considered official time within the meaning of the legislation and for the purposes of calculating compensation percentages. And with that, Mr. Chair, I would yield back my time.
Gentleman yields back. We'll now recognize the gentleman from Georgia, Mr. Heist, for 5 minutes.
Thank you, Mr. Chairman. Again, H.R. 1364 does not hinder or prevent anyone from exercising the First Amendment or raising a red flag or whatever concerns they may have. The bill is simply prohibiting lobbying and political activities for those who are on official time. I don't see how we can get any more reasonable than that. The bill is targeted to prevent employees from engaging in partisan activities on the back of taxpayers. We've gone through this over and over. You know, for example, we heard earlier from the gentlelady from North Carolina, Ms. Fox, there in the VA in Salisbury, North Carolina. Members of the VA picketing on official time. They should not be able to do that. And this bill stops that kind of activity. It does not take away any time from anyone who wants to serve on official time. They're able to do so. It just prevents the political activity, political activism, such as the grassroots activity, and it prevents anyone who is 80% official time or more from receiving retirement benefits for that time. At the end of a year, if someone wants to reevaluate, they can continue on 100% if they want to, or they can choose to have someone else. But this, I again oppose the amendment. It's unnecessary. People are still allowed to be on official time and address the concerns that the gentleman has brought up. So I oppose the amendment and urge my colleagues to do the same. I yield back.
Gentleman yields back. Now recognize the gentleman from Pennsylvania for 5 minutes.
Thank you, Mr. Chairman. I speak to support the amendment offered by the gentleman from Maryland. Union representatives use official time to defend the rights of employees who blow the whistle. They blow the whistle on waste, they blow the whistle on fraud, they blow the whistle on abuse, they blow the whistle on any form of mismanagement, and conflict of interest is perhaps the worst form of mismanagement. And so mismanagement includes employees who speak out when another employee has a conflict of interest that might cause that employee to act in his or her own self-interest instead of the interests of the United States and the American people. And that's what conflict of interest means. It means deciding things on behalf of the American people, not because they make sense for the American people, not because they're prudent and sound judgment, but because they enrich the person who is making the decision. And unfortunately, this is more than just a hypothetical concern these days. With this new administration, we have seen an unprecedented number of financial and other kinds of conflicts of interest that could affect how administration officials do their jobs, but how will we know? How will we know when an official has an undisclosed conflict of interest? We depend on whistleblowers for this very problem. Those brave employees who have the nerve and the temerity to risk their careers to speak out. And those whistleblowers depend on union representatives using official time to defend them. I've spoken before, earlier today, about the beneficiaries of whistleblowers being defended by official time. The President of the United States, our veterans in the VA system, our men and women who work in the Bureau of Prisons, but we're talking about whistleblowers of every variety who catch people making bad decisions for the wrong reasons, and that includes conflicts of interests. This amendment would exempt H.R. 1364 any official time spent on identifying, preventing, or addressing conflict of interest issues. And so it is a good amendment. I congratulate my friend from Maryland for coming up with it, and I urge my colleagues to support his amendment. And Mr. Chairman, I yield back the balance of my time. I yield to my colleague from Maryland.
Yeah, in the 2 minutes remaining, I just wanted to echo those comments. I think it's an outstanding amendment. In a way, making sure that an agency isn't suffering from or afflicted by conflicts of interest is a baseline foundational issue upon which you then build all the rest of the efficiencies and the kind of sturdiness of how that agency delivers its services. So I think it makes perfect sense that any activity that involves addressing conflicts of interest, making sure we're taking care of that kind of threshold integrity of the agency, not be time that gets calculated into the official time, because it really forms the base, the foundation upon which all the rest of these things occur. So I want to congratulate my colleague for the amendment, and I support it, and I yield back.
I will say that we're hearing a lot of great good sense from the representatives from Maryland today, and I thank them for that. This is the committee where we are dedicated to rooting out waste, fraud, and abuse, that unholy trinity, and union representatives working on official time defend the whistleblowers who catch people up to the waste, fraud, and abuse and the conflicts of interest that Mr. Raskin is talking about. So I urge my colleagues to support his amendment, and I yield back. Mr.
Gentleman yields back. Does any other member wish to speak on the Raskin amendment? If none, the question is now on the amendment offered by the gentleman from Maryland, Mr. Raskin. All those in favor signify by saying aye. Aye. Those opposed, no. No.
I ask for a recorded vote.
Roll call vote has been requested. As previously announced, further proceedings on the question will be postponed. Does any other member wish to strike the last word or to offer an amendment? The gentlewoman from the Virgin Islands, Ms. Plaskett, is now recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will designate the amendment.
Amendment to H.R. 1364 offered by Ms. Plaskett of the Virgin Islands.
Without objection, the amendment is considered as read, and the gentlewoman from the Virgin Islands is recognized for 5 minutes to explain her amendment.
Thank you. Mr. Chair, I have an amendment that would give an exemption to this in that any time spent protecting employees from sexual harassment shall not be considered official time for purposes of calculating such percent. And the reason I'm asking this is that H.R. 1364, as it stands now, will have the effect of punishing federal employees for protecting victims of sexual harassment. I know that the chair nor anyone in this committee would want that effect or that on their hands. My amendment would make an exemption for any time spent protecting employees from sexual harassment from consideration as official time for purposes of calculating such percent as provided in this legislation. Sexual harassment is a major problem in today's workplace. The large number of charges filed with the Equal Employment Opportunity Commission annually and the results of workplace surveys demonstrate that harassment is widespread and it's ongoing. Sexual harassment is prohibited by federal and state law, but enforcing that law in the workplace often falls to unions and federal employees on official time. Workers look to their union representatives for protection against sexual harassment or any form of civil rights violation in the workplace. Union representatives help collect the evidence of the violations and defend the rights of victims. Union representatives conduct laborious hours of investigation to document cases of sexual harassment. These representational functions are conducted during normal working hours. It is a standard for agreements between government agencies and the unions to recognize that appropriate use of official time benefits both the management and labor. These agreements generally provide that the purpose of official time is to provide bargaining unit employees time in which to perform union representative activities during the normal working hours without the loss of pay or change in annual level. We believe that H.R. 1364 undermines these activities by not allowing activities like defending the rights of victims of sexual harassment to count towards credible service under the Civil Service Retirement System and Federal Employees Retirement System. As the law, if we were to pass 1364 stands now, when would union representatives be able to collect the evidence of sexual harassment in the workplace, except during the time that they are there in the workplace, which would be during the regular working hours? The restrictions would have a chilling effect on the time that union representatives spend on working to protect federal employees from violations of their rights, including sexual harassment. We cannot afford to eliminate the protections against sexual harassment that unions offer in the workplace. That is what H.R. 1364, as it stands now, would do. And I'm urging my colleagues to support this amendment.
Thank the gentlewoman. We'll now recognize the gentleman from Georgia, Mr. Heist, for 5 minutes.
I thank the chairman, and I thank the gentlelady from Virgin Islands. You know, this amendment has nothing to do with official time. I mean, we are all opposed to sexual harassment, and as you mentioned yourself, it is clearly illegal, and nothing changes in that. You know, there seems to be a continual beating of the drum that somehow H.R. 1364 eliminates participation in official time. It does not. It does not harm official time. It does not impact in any negative way whistleblowers who identify problem areas, including certainly sexual harassment. That's not what the bill addresses. It addresses political activity and those who are using 80% of their time in official time rather than the purpose for which they were hired by whatever agency, that they would sacrifice after a year their retirement for 80% or more of their time. Look, we're talking 80%, we're talking 1 day a week doing your job that you were hired to do. That is not a huge task, seeing that that's what individuals were hired to do. But if they choose to do so, they can. And this bill doesn't prevent them from doing so. So again, I oppose this amendment. It's unnecessary, and I urge my colleagues to do the same.
Gentleman yields back. Does any other member wish to speak on the Plaskett amendment? Ms. Watson-Coleman of New Jersey is recognized for 5 minutes.
Thank you, Mr. Chairman. There are a couple of comments I want to make. One of them that was just made said that this does not in any way negatively impact official time, but indeed it does, because it provides a chilling effect on anyone who would be willing to do this on their time, because it negatively impacts their pension at some point. And so indeed that is an inaccurate statement. But secondly, this bill probably isn't necessary anyway, because unions are already precluded from doing the kind of illegal activities not illegal activities, because even in the era in which we are now, illegal activities aren't allowed. union activities or political activities. But yet we're faced with this bill, and so you got to really question the motivation for the bill in the first place. And lastly, there have been a number of amendments, even in the face of this being an unnecessary, mean-spirited bill, to make this bill more palatable, to ensure that there's protection of employees or the opportunity for employees' issues to be remediated, and to do so in a cost-effective way so that you don't have to have protracted legal proceedings. And none of these amendments has been seriously or objectively considered by our colleagues on the other side. So that further puts into question the motivation behind what is already a terrible bill. And with that, Mr. Speaker, I'd like to yield the balance of my time to my colleague, Ms. Plaskett.
Thank you very much. I understand and I'm grateful that my colleague across the aisle does agree that sexual harassment has no place in the workplace. But what time does he think that any allegation of sexual harassment would in fact be investigated? One could, of course, make the allegation, but if there is not time for an individual in the workplace or union representative to collect the evidence or to question individuals or to procure that information that's necessary to bolster that harassment allegation, then it would have a chilling effect in that the allegation would just be a voice in the dark with nothing to substantiate it, with no means, in fact, to determine if, in fact, it was incorrect and was a frivolous allegation made by an employee against another individual. So that's why this amendment is necessary, to ensure that frivolous allegations or substantial and truthful allegations could in fact be investigated by union representatives during the workplace, during the most appropriate time to investigate those charges of sexual harassment, to ensure that they are gotten to very quickly. We know that the union representatives see these things on a regular basis, on a weekly basis, on a monthly basis, and they're able to quickly ascertain which are true and which are in fact frivolous, so that they can be expeditiously dealt with in the workplace, so that it does not linger and become a morale drain on all of the employees within that agency. And that's why this amendment is necessary. Listen, I think that we have not given, we've given short shrift in this committee to all of these amendments, that we have not really looked and seen which ones could in fact be a substantial of some improvement on the bill as it stands. And so I would ask that, we give real consideration to this. If we say we want to be a bipartisan committee, if we say we want to be a committee that's working towards finding the common ground, at least consider some of these amendments in which they're standing, instead of just going across party lines and determining no to every amendment that comes from the Democratic side. Mr. Raskin, would you yield to Mr. Raskin?
Yield to Mr. Raskin.
Thank you very much. Sexual harassment has been a pervasive problem in the federal government. Huge scandal in the 1980s and 1990s at the Securities and Exchange Commission. There have been repeated scandals in the Secret Service, in the armed services about sexual harassment. And what's the big problem? We are assured by the bill's author that these things are illegal. Sexual harassment is illegal. On the other amendments, conflict of interests are illegal. Waste, fraud, and abuse are illegal. But the whole point is that the law doesn't enforce itself. There's a difference between the law on paper and the law in practice. You need actual human beings to summon up the moral and political and sometimes physical courage to overcome their fear, to overcome intimidation, to come forward to complain about waste, fraud, and abuse, and sexual harassment, and racial harassment, and conflicts of interest, and so on. And the problem with this bill is that it sweeps far too broadly in terms of nullifying the kind of speech that we need in order to blow the whistle on these activities. I have a couple more things to say, but I will yield back and seek recognition by the chair.
Thank you. The gentlewoman yields back. Before she yields back, would the gentlewoman yield to me for just a quick comment? I would just note that we did accept the Cummings amendment earlier in this markup, so we do, when it's warranted, on occasion, accept Democratic amendments. That's all I wanted to say. The allegation was that we don't accept the Democratic amendments, and in this markup we already have. So with that, I yield back. The gentlewoman yields back. Now recognize the gentleman from Maryland, Mr. Raskin, for 5 minutes.
Thank you again, Mr. Chairman. So, but I wanted to go to the underlying point for a second that's been raised by our distinguished colleague who introduced the legislation, where he said, basically all we're saying is that if you're going to spend 80% of your time representing your fellow workers in complaints, then you should lose the full benefit of the compensation that you have negotiated for, implying that there's something wrong with people acting in the capacity of a shop steward. Now, those people who have worked in workplaces where there's union representation know that the shop steward position is a critical and vital position. It's not somebody blowing off their responsibilities and not somebody taking vacation in the Virgin Islands, although perhaps the good delegate could make that possible for some of us. No, the shop steward plays a vital role, and labor management scholars all concur about this. The shop steward resolves conflict within the workplace. The shop steward facilitates the work of the enterprise. And it's the same thing in the federal context. If you don't have one person who takes 80% of her time to represent her fellow employees, then you've got dozens and dozens of people all trying to represent themselves whenever something goes wrong. That's basically the function of official time. Now, I want to say something else about how this 80% works. When you read the fine print of this legislation, it doesn't just say that you're disqualified for your contractual consideration, what you've bargained for, if you spend 80% of your time over the course of the year. It's even 80% in one day, then you lose the benefit for that day. And that's a serious problem because a lot of the collective bargaining agreements provide that there will be 1 day a week, a fifth of the person's time, when they will engage in representational activity for their fellow employees, but suddenly that day is removed from their contract for the purposes of accruing the various kinds of benefits that are being eliminated by the legislation. So you could spend 1 day a week, 20% of your time, but if you spent the whole day there, more than 80% of the day, then that day is lost to you in terms of building up your pension credits and so on, which is just one more hidden pernicious feature of this legislation, and one more reason that we do need to make certain, at least for things like defending your fellow workers against sexual harassment and blowing the whistle on that, we carve that out from the application of the legislation. So I want to speak very strongly for the Plaskett Amendment, and I will yield back my time, Mr. Chair.
Gentleman yields back. Gentleman from Massachusetts, Mr. Lynch, is recognized for 5 minutes.
Thank you, Mr. Chairman. Will the chairman help me with a term here? Does the chairman know why the line was drawn at 80%? Was there a study done, or it says principally engaged in official time, and then it says 80% in the legislation? Well, my point is that it's an arbitrary and capricious line that's been drawn here. There's no magic to it. It's just, I believe the sponsor of the bill just came up with 80% and figured out, stick it in there. The problem is that it limits a constitutional right of these workers to actually bring their grievances forward and have the right to free speech in the workplace. Also, it is important to note that if an individual union steward was working on a case of sexual harassment, has been brought up by the previous speakers, and reached that 80% limit, that person would be confronted with the dilemma of either pursuing the case beyond 80% and losing their pension time, or giving up the case, in which the grieved employee suffering from sexual harassment would be harmed. And that would be bad in both cases. And I think it's fair to say it's a prior restraint on a constitutional right in any event. The interesting thing here is that the management side gets no penalty. So they can work on matters of labor relations and personnel policies till the cows come home, and they are not penalized. So I think you've got an equal protection problem there. I see the gentleman who's the sponsor of this bill. May I ask, Mr. Heist, if there was any magic in the 80% beyond the limit at which someone may be principally engaged in official time? How did we come up with 80%?
Yeah, there's nothing magic about it.
Is there any rational basis?
I've often wished there was some sort of magic around here, but there's not. No, listen, last year I introduced
Did you just think it up? I'm just asking.
Yeah, last year I introduced a bill on official time that was much more stringent than this. I mean, to be honest, if I had my choice personally, any time on official time should not be credited towards retirement because it's not what they were hired to do.
Well, at least you're honest.
Yeah, and so listen, I'm answering your question.
Okay.
And so we decided, look, my wishes are not going to be sufficient. So let's be as reasonable as we can. 80% seemed like an extremely reasonable amount that if a person's working over 80% of the time in the job that they were not doing a job they were not hired to do, it seems extremely reasonable, beyond reasonable to give that.
Was it derived from any?
I just told you where it was derived. It's just from trying to be overly reasonable.
You thought it up? Is that what it is?
Yeah.
No, you thought it up. Okay, that's fair enough. Fair enough. I'm just trying to
thought it up
establish a
based upon
basis.
what seemed to be overly reasonable.
I understand. No, that's good. I appreciate the gentleman's honesty. I just want to try to set the table for a challenge here that this is arbitrary and capricious, which is basically you just thought it up, which is good. That kind of fits the definition right there. Okay.
Would the gentleman yield
back? I would certainly yield to the gentleman from Maryland.
Thank you very much, Mr. Lynch. And because we've got the sponsor back in the room, I wonder if I could follow up with a quick question on this. Mr. Heist, if I could just follow up with a question, since it is your design of the legislation, and congratulations on its success so far. It seems to have achieved a lot of consensus on your side of the aisle. But you've said repeatedly that this is...
Members are reminded to address...
Forgive me, Mr. Chair.
To the chair.
Yeah, forgive me. Mr. Chair, the legislation has been characterized as applying only when 80% of a person's time is used. I'm reading it to say that if it's 80% on a single day, that day no longer counts towards your pension credits. Was that the intention?
It's for a year.
For a year.
80% over a year, and then they can choose to lose for the next year. If the next year, it would begin to apply.
Okay, so it's not tabulated on a daily or weekly basis. Thank you for that clarification.
The gentleman's time has expired. Does any other member wish to speak on the Plaskett amendment? The gentleman from Pennsylvania, Mr. Cartwright, is recognized for 5 minutes.
Thank you, Mr. Chairman. I speak in support of the Plaskett amendment. The gentlelady from the Virgin Islands is making a lot of sense, and it does make sense to protect employees using official time to stick up for employees who are subject to sexual harassment in the workplace. That makes sense in the private sector, and that makes sense in the public sector. But we've been bandying about this 80% discussion. A couple of points there. Number one, when your neighbor comes to you and says, well, I want 100% of your property, I want to take it away from you, but I'm willing to be reasonable and I'm only going to take 80%. That's not much of an argument. And that's what we're doing here is we're saying, well, people are going to lose money. Employees are going to lose money because they're doing work that we've already been at some pains to discuss benefits so many Americans, benefits American veterans, it benefits employees at Bureau of Prisons, it benefits people who are protected by the Secret Service, for heaven's sakes. And so to dock them pay for defending whistleblowers who protect all these people, it makes no sense. And the other point is, when we use the figure 80%, it sounds a lot like, it makes anybody who actually tuned in to watch this hearing, first of all, I would say there are other channels available. But maybe more importantly, they might get the impression that we're here defending federal employees using 80%. We're defending hiring a federal workforce that uses 80% of its time to do union activities. It could not be further from the truth. So if anybody has just tuned in and thinks that that's what we're talking about, realize this: according to the Office of Personnel Management, the government-wide cost of official time in fiscal year 2012 was $157 million, and that was only 0.1% of the cost of all of the salaries and benefits for all federal employees. So we're not talking about 80% of anything here. We're talking about 0.1% of federal employees' time is spent in official time defending whistleblowers and sticking up for protections that all right-thinking Americans believe in, and these people ought not to lose their pay over doing that kind of work. Mr. Chairman, I yield back.
Gentleman yields back. Any other member wish to speak on the Plaskett amendment? Ms. Kelly from Illinois is now recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to yield my time to Mr. Raskin.
Thank you very much, Ms. Kelly. I wanted to just return to this question of the 80%, because I feel that the full committee doesn't have a full fix yet on what exactly the bill says. It seems one representation to us has been that if you're spending 80% of your time over the course of a year, then that year is removed from the tabulation of your service for purposes of pension credit. Okay. Now, this raises two issues, Mr. Chairman, and I would love it if we could get to the bottom of this. And this is not an ideological or a polemical question. It's purely a factual and empirical one, okay? Because my reading of the bill is quite different, okay? For one thing, I believe that if you spend 80% of 1 year doing this, you lose the entire year, even if that's 1 year out of 20 years in your career. So you could spend 5% of your career as a shop steward, or, essentially representing other people's rights, but you would lose that whole year, even though it's only 1/20th of your entire career. So, but I just want to know if that's accurate or if it's not accurate. Are we basing it on your entire service, or is it year by year? And if it is year by year, okay, then I'm looking at another provision in the bill, which is Section 3, on page 3, lines 17 through 21, and it says, for purposes of this subsection, an employee spends a day principally on official time if at least 80% of the time such employee would otherwise be in a duty status during such day is spent on official time granted. It seems to me this provision is opposite to what we were just told. In other words, it makes it sound as if we are counting by the day, not by the year. And I just wonder if we could get some clarity on that. I mean, obviously, I would prefer to count by the year than by the day, because I think that the shop stewards and the employees who step forward to represent other people's rights and whistleblowers should at least be able to spend a day helping their fellow workers without being penalized for it. And I don't know whether anybody could offer any clarification as to this point. Because the prior section says an employee may not be allowed credit under the section for any day of service spent principally on official time, as described under subsection B.
I can simply point the gentleman to section 3 of the bill.
Okay, right, I was quoting from section 3. So, in other words, I take it then that the last representation has been corrected then, that it does go on a daily basis as opposed to an annual basis? Forgive me, I'm just confused, Mr. Chairman.
My role here is not to answer questions.
Oh, I'm sorry,
I'm just pointing you to the text.
I got you.
You interpret it, it's section 3.
Could the sponsor answer this question, or? Oh, okay. Well, look, Mr. Chair, we're moving very fast here to...
Will the gentleman yield?
Yeah, yes, by all means.
I don't know who it was that offered a very helpful response, indicated that there's some unions who have bargained 1 day a week based on the interpretation that you have just indicated by the day. And so if you wouldn't even have other days if you went over the 80%. So I think by the day is the meaning of the provision.
Yes, and this is basically my problem with it. It's really not an 80% rule, it's a 20% rule. If you spend 1 day a week, you lose that day. And you see, we're really undermining an essential part of labor management relations in the federal workforce by stripping a day that an employee would spend on behalf of his or her coworkers. I would yield back, Mr. Chair.
The gentleman yields back was actually Ms. Kelly's time.
Me.
Right, and I believe Mr. Lynch has already been recognized.
I had a parliamentary inquiry.
Sure.
Would it be possible to recess until we get an answer to Mr. Raskin's question? Because this is just regarding the meaning of the bill. I think there's a serious question as to the explanation he gave us is not in harmony with the text of the bill. That's all. Thanks.
So you're suggesting that we
just get Mr. Raskin back in here. I mean, excuse me, Mr. Heist back in.
We have other members who may want to speak on this particular amendment. If we can do that while he goes, I believe Ledge Counsel is there in the audience if they want to go ask.
Okay.
She can answer questions for you if you want to walk over and go ask her some questions while we continue on.
Okay.
I suggest huddling with her and...
Mr. Chair, would it be proper to just pose the question for the benefit of the whole committee to Legislative Counsel for clarity on this point?
Yeah, that'd be great.
Okay, can we try that? Everybody, unanimous consent that we try to do that? Let's do that. Some interlude music, appreciate that. Thank you.
Thank you.
As we move the microphone, I appreciate the Wisconsin polka coming to rescue.
I'm looking at page 2, lines 20 through 23, where you were referring to before. The 35 days says in the aggregate, which would mean those days do not have to be consecutive. As the language is written, any day of service beyond 365 total days in the aggregate that is spent principally as defined in paragraph 2, over 80% official time, would be eliminated from creditable service calculation.
If I can pursue the questioning, Mr. Chair. So just to be clear about it, if a member of a bargaining unit were to spend a day a week over the course of a year engaged in representational activity and defending whistleblowers and so on, then that person would not lose time. Is that right? Because that would be considered 20% or over the course of a year?
Those individual days would be counted in line 23 to the 365 days in the aggregate over the career of the individual.
Okay, so it's always tabulated over the course of their whole career?
There is no language stating otherwise.
Okay, so to be clear, are you reading it that official time is defined at the end of a person's career?
I'm not interpreting anything. There's no language that states that it is career-wide, but there is no language that states that it's limited in any other way. It is 365 total days in the aggregate, and any day spent above that principally on official time would not be counted as creditable service for that individual.
Okay. All right, then thank you for that. The way I'm understanding it then is that under the legislation, that a person engaged in representational activity would have a total of 365 days to do it before it begins to remove credit from pension and other compensatory benefits that they may have bargained for. Does that sound right to you? You have 365 days before the legislation kicks in?
Yes, any day above 365 would not be counted.
Okay. Thank you very much.
Does any other member wish to speak on the, we're still on the Plaskett amendment. Does any other member wish to speak on the Plaskett amendment? The gentlewoman from the District of Columbia, Ms. Norton, is recognized.
I think we might be about to close out on this amendment. I appreciate the Plaskett amendment. In the process of responding, our good friend made an important concession. He said if he had it his way, there'd be no time. That means he does not understand whose business this is. This is not union business.
The gentlewoman will suspend. To suggest that the gentleman who offered this bill doesn't know or appreciate is not an appropriate, to assign his motivations is beyond the scope of the rules of the committee.
I'm not speaking motivation, Mr. Chairman. I'm going to indicate why I believe that his own words, that if he had his way, there would be no time, means that he has not looked closely at what the statute says. It's called official time for a reason. This is agency business. It keeps disputes from disrupting agency business by finding an orderly way to deal with them, bringing people to the table, labor and management. Why are my colleagues coming forward with some subjects that they argue should not be included in this 80% time cap? It's because some subjects are in a class by themselves. That's why I believe in a prior amendment you heard members talk about whistleblower. They were only talking about what this entire committee on a together, I don't even have to say, together had agreed upon, and it's kind of set it aside because it's very special. And that's what the Plaskett Amendment is about. Had we given the same kind of attention to sexual harassment? Very recently, federal employees from the EPA and the Forest Service were subjected to sexual harassment. So we picked it out. We felt that was so serious, we had to have hearings on it. We don't have hearings on every kind of violation. But when it rises to that level, it seems to me that you want to make sure it isn't caught in any 80% time cap. That was just 3 months ago that we had that hearing. We were so concerned that we wanted a workplace that was free of sexual harassment. I must say, Mr. Chairman, you gave some of the strongest words I've heard you indicate in that hearing. So by choosing out certain subjects, and Ms. Plaskett chooses out sexual harassment, she's trying to keep the committee from saying one thing and doing another. If it's so special that you have hearings, if it's so special that even the chairman speaks out against it and stands up for it, if the whole committee has been standing up for the victims of sexual harassment, then it should be treated just as we have treated it, as a special and important subject. And the way to make it clear that it does mean something to us is to send the message, you got a sexual harassment matter, we're not going to put a time limit on it. We know how difficult it is to come out for sexual harassment. It takes a great deal of courage to even come forward, and then to get it all out, that requires us to allow the time necessary to prove a matter which, by the way, is very difficult to prove because it's often he said, she said. So I strongly support the Plaskett amendment. I, as a chair of the Equal Employment Opportunity Commission, administered Title VII, where sexual harassment was a very important element of what the commission did, and I think this committee agrees as well. So I ask that the committee approve the Plaskett amendment.
Gentlewoman yields back. Does any other member wish to speak on the Plaskett amendment? If none, the question is now on the amendment offered by the gentlewoman from the Virgin Islands, Ms. Plaskett. All those in favor signify by saying aye. Aye. Those opposed, no. No.
Mr. Chairman.
Roll call vote has been requested. As previously announced, further proceedings on the question will be postponed. I believe Ms. Lawrence of Michigan is recognized.
Yes. Thank you, Mr. Chair. I have an amendment at the desk.
The clerk will designate the amendment.
Amendment to H.R. 1364, offered by Ms. Lawrence of Michigan.
Without objection, the amendment is considered as read, and the gentlewoman from Michigan is recognized for 5 minutes to explain her amendment.
Mr. Chairman, my amendment is simple, and it creates an exception for any time spent protecting employees from unlawful discrimination. We've had a long dialogue about sexual harassment. I want to broaden that. This legislation would create a dangerous precedent by intimidating union stewards into not advocating for their fellow employees. And if we have a situation like we have been aware of whistleblowing, where there is a culture of discrimination or sexual harassment, where the workload for a union representative would be substantial, the employees that we fight to protect would be also affected. One of the scenarios, and I want my colleagues, if they would, to listen, as I have no colleagues now listening, but for the record, when an employee feels that they are being treated unfairly, the person that they have direct access to is a union official. Oftentimes, when they meet with their union official and they define their issue of being aggrieved, they understand, or they're advised by the union steward, that this is not a contractual issue, this is discrimination under Title VII, and advise them to see an EEO investigator. As you know, I served as an EEO investigator, and numerous times cases were referred to me from a union steward. If that union steward had not taken the time to counsel that person, a lot of times they don't even understand the procedure to contact a person to file a complaint because they're not on site for discrimination. Now, what is discrimination in workforce? It takes various forms. It includes race, gender, sexual orientation, color, age, religion. And oftentimes, because you have the right as an employee to have someone represent you, that union steward is tapped to please sit with me and represent me through the EEO process. Mr. Chairman, I'm baffled that our committee is willing to punish union officials for filing grievance on behalf of victims of discrimination, which is the law, Title VII. This is not the way to strengthen our federal workplace. It will completely create a different outcome. The Civil Service Reform Act of 1978 authorized the use of official time. Why are we sitting here legislating something that has been authorized for official use? And it has been stated repeatedly that it is negotiated through the agency and the union of what is considered reasonable time. Again, I see this body reaching into areas to legislate beyond the congressional intent of this committee. And there has been no complaints that I'm aware of, and I have not heard anyone advocating for this, that there has been a complaint of abuse. We heard the numbers. We do not have an issue of major abuse of official time. There's things I don't like in the government, but when the law says that it is a benefit or a right of an employee, and now I'm advocating that if I'm being discriminated in the workplace and I tap my union official to help him to guide me through this process, that my union steward may say no, because I have to keep track of my time and I'm not going to lose my benefits that I provide for my family to do the job to protect your rights. You have to talk to someone else. Mr. Chairman, I employ my colleagues to support this common sense amendment to prevent workplace discrimination, and I really am so challenged to understand why we're trying to fix something that has not been an issue. But when it comes to discrimination, and having served myself personally and heard the complaints and discrimination that has happened in the workplace, and we want every employee to be protected and work in an environment that they do not have to be the subject of discrimination, why would we tie that into fixing something that I'm still challenged to understand that's broken? And I yield back my time.
The gentlelady yields, and I will recognize myself. This amendment provides exceptions to the underlying bill. The amendment specifically exempts official time spent on protecting employees from unlawful discrimination from the benefit reduction provided in the underlying bill. All of us agree that federal employees should not face unlawful discrimination in the workplace. We get that, and we all agree with that. However, let's be clear with this. Official time work supporting employees facing discrimination can still be carried out under this bill. The bill does not take away official time. So H.R. 1364 is merely giving these employees a decision point about their financial interest versus the taxpayers when they decided to be almost full-time official time for a year or the years, whatever the case may be. And so, we're kind of chasing rabbits around and around. This bill does not take away official time. And so with that, I encourage my colleagues to oppose this amendment. Does anyone else wish to speak? I yield that. Yes.
Mr. Chair.
Mr. Chair recognizes Mr. Lynch.
Thank you very much, Mr. Chairman. I have to admit, though, that may I get my own 5 minutes?
Yes, sir.
Oh, okay, all right, because this is 1:50. All right. I honestly have to say that the sole redeeming quality of H.R. 1364 is that it is flatly unconstitutional and will likely never see the light of day and never get through the Senate, and certainly will be struck down at the first instance by any sober judge. It includes penalties that are imposed for an employee exercising his First Amendment rights to petition the government. It applies penalties that strip pension credits, pension benefits for an employee who actually works 5%, not 80%, but 5% of their time on official time. And I want to go through this again because we had a rather convoluted discussion about the definition of principally on official time. If the gentleman would work with me here, under Section 3, it says that there's an aggregate maximum of 365 days that any individual may work on official time. Is that correct?
It is referring to, it is an aggregate a year-long
right, in a person's
determination
career.
of the 80%.
Yeah, but so a career is standardly referred to as at least 20 years. So if you can work 365 days out of 20 years, that's 5%. So if I'm a union steward, which I have been, and I work 1 year as a union steward in a 20-year career, I'm done. If I work 365 days as a steward on official time, I'm done. I've got to stop representing employees after year 1, and I've got to work the other 19 years, and I got to stay off of official time. That's the import of this bill.
It's 1 year at a time. The intent of the bill is an aggregate year at a time. The first year is free. Beginning the second year, if 80% or more is used, for official time, they would sacrifice their retirement for that year.
So
the next year they may go back to 50%
but it says here 365 days in the aggregate. So if in the first year I do it 365 days, which is a year, it assumes I'm working weekends, but if I do 365 days a year, and now I reach my aggregate maximum, in year 2 I cannot work. Otherwise I forfeit that year as well, because I'll be over in that year.
Look, Ledge Council has already read this. And
no, not this part. Not this part. We didn't do this analysis.
Well, they dealt with the Would the gentleman like to recognize counsel?
Sure. Sure.
So you get the first year. You can work a year on official time. That's what the 365 days. After that year, that's when this 80%.
Okay. All right. Hi.
Hi.
So explain to me the consequences if I work my first year, 365 days, on official time as a union steward. What is my predicament in year 2? I think that would be the good question.
If for 365 days, you spend at least 80% of the time you would otherwise be in a duty time on official time,
Yeah.
your 366th day would not be counted as creditable service.
And what about the 367th day?
No day beyond 365 days total would be counted for creditable service.
So I'm dead for my pension if I do 366, 367 on official time going
I
forward.
believe that question requires interpretation.
It requires addition. It does. Well, wait a minute. Explain to me, this is your bill.
I'm sorry, I'm Ledge Counsel. Mr. Heist is the offerer of this bill and the sponsor.
Are you refusing to answer?
I can interpret the bill language as written. Well, I shouldn't say interpret. I can tell you how the bill is read as written.
Yeah.
But I can't speak to the intent.
I'm not asking about intent. I'm just asking, we're just taking a hypothetical situation where somebody, as I just explained, an employee, let's call him Joe Jones, he has worked 365 days of official time, and he keeps on doing it in the next year.
Any day of service, this is page 2, line 21, any day of service spent principally on official time in excess of 365 days will not be counted for creditable service.
Exactly. Exactly my point. So he loses his pension for the rest of his career once he reaches that 365 days. That doesn't allow people to use official time. The statement earlier on was this has no effect on official time. This kills official time after the first year for that employee for the rest of his 20 years. I'll yield back.
Gentleman yields back. Does any other member wish to speak on the Lawrence amendment?
Mr. Chairman.
Oh, yes, Ms. Demings is recognized for 5 minutes.
Thank you so much, Mr. Chairman. I am pleased to give full support for the amendment proposed by Ms. Lawrence. You know, we've spent a lot of time in this country working to protect citizens and certainly our workers from unlawful discrimination based on the list that you've already heard on race, color, religion, gender, sexual orientation. And it's been interesting, too, to listen today as we talked about the work of union representatives as if somehow the work that they do to protect our employees is not real work. But when we really look at the work that the labor representatives do, they work with management to ensure that they provide work environments conducive to fulfilling the mission. They work with management to resolve problems that can undermine the official operation of the organization. They negotiate contracts, and of course, as we've already said, and have to come to an agreement with management as it pertains to unlawful discrimination and how it will be dealt with. We talked earlier about determining a safe working environment, that union reps help identify safety and health hazards in the workplace. When the workplace is safe, I think we all know that workers tend to use less sick leave and workers' compensation benefits. And then in the grievance process and disciplinary actions, due process is crucial in a democratic society. It is definitely needed in the federal government, as we've seen in so many cases. So as we deal with this issue and talk about the use of official time and protecting employees, I believe one of the most sacred and most precious is the protection of employees from unlawful discrimination in the workplace, and we should not place any limits on the use of official time in order to do that. Thank you, Mr. Chairman. I yield back.
The gentlewoman yields back. Does any other member wish to speak on the Lawrence amendment? Ms. Norton of the District of Columbia is recognized for 5 minutes.
Mr. Chairman, the Lawrence Amendment is not only about one of the oldest and most important issues in our country. I want to suggest that of the number of ways we have to solve discrimination, this may be, in many ways, the best. And I say that as somebody who was an official that administered one of those ways. Think of it, Mr. Chairman. An employee has a discrimination grievance. If, in fact, that matter is dealt with as a labor management in a binary way, so the parties are brought together, instead of ballooning into a full Title VII complaint, what you have is a less contentious and less expensive way to, in fact, resolve a discrimination complaint. Now, as I indicated, there are a number of ways to resolve such a complaint, number of remedies. But in a very real sense, if you have both parties before you, no subpoenas, no formal hearings, just a matter of negotiation, then a great many discrimination complaints could be resolved very easily. And that's why I think the Lawrence Amendment has much to recommend it, and I strongly support it. I yield back, Mr. Chairman.
Gentlewoman yields back. Any other member wish to speak on the Lawrence Amendment? If not, the question is now on the amendment offered by the gentlewoman from Michigan. All those in favor signify by saying aye. Those opposed, no.
Aye.
No.
Mr. Chairman, I ask for a recorded vote.
A roll call vote has been requested as previously announced. Further proceedings on the question will be postponed. Does any other member wish to speak on the bill or to offer an amendment?
Mr. Chairman, Mr. Cummings has an amendment at the desk, and I'm pleased to offer it.
The gentlewoman, the clerk will designate the amendment.
Amendment to H.R. 1364, offered by Ms. Norton of D.C. on behalf of Mr. Cummings of Maryland.
Without objection, the amendment is considered as read, and the gentlewoman from the District of Columbia is recognized for 5 minutes to explain the amendment.
Mr. Chairman, the Cummings amendment simply ensures that the 80% cap, the limitation on official time, does not apply to union representatives who are representing non-union members. That may be most members. In fact, most federal employees are not members of unions. And of course, those may be the employees less likely to bring complaints. Of course, during these proceedings, during this hearing, my colleagues have referred to official time as union activities, but in real sense, as I indicated earlier in an earlier comment, that this is really a misnomer. We're talking about official time. We're talking about time, business, agency business, resolving matters that arise in the agency context, except it's, in this case, it's management and labor, and you're trying to solve it. Now, the law prohibits the use of official time to conduct union-related business, and no one here has disagreed with that. But the Office of Management and Budget has described, and here I'm quoting, official time as a critical component of the carefully crafted collective bargaining system that Congress created for the federal government. You don't have to belong to a union, and I repeat again, that is a choice. In order to be represented, you don't have to belong to a union. If you want to preserve that, you've got to make sure that non-union employees feel that they can be so represented. And one way to do so is to make sure that a union rep doesn't feel that representing this non-union employee who hasn't paid any dues is an employee who shouldn't be given the same kind of time that union employees are given. In fact, we want to make sure that the non-union employee is given very special attention. One way to do that is to assure that the ability of union representatives to continue to meet their obligation to represent non-union members is not counted in the 80% cap. I yield back, Mr. Chairman.
Gentlewoman yields back. We'll now recognize the gentleman from Georgia, Mr. Heist.
Thank you, Mr. Chairman. The Cummings Amendment seeks exceptions to the underlying bill. This amendment would specifically accept time spent representing non-union members in grievances, disciplinary issues, and other employee-related issues. The amendment raises an important topic about the role of official time in supporting grievances. The Subcommittee on Government Operations recently heard testimony that subsidizing union activity via official time gives union representatives the opportunity to file frivolous grievances and other appeals. It was interesting in that hearing that testimony was found that of the 4,300 grievances filed before the FLRA in 2012, unions initiated over 90%, and the FLRA found an actual violation in only 13 instances out of 4,300. That's 0.3%. However, tabling that discussion, H.R. 1367 does not take away official time. Agency's current maximum allotment of official time remains the same. The bill does, as we've mentioned before, remove a financial incentive for federal employees to be on nearly full-time capacity for multiple years in a row. The amendment before us detracts from that goal. This amendment is unnecessary because the type of work described by the amendment can still be carried out by the employees on official time. This type of work can also be carried out by those who choose to stay on 80 to 100% official time longer than a year and choose to forego certain benefits. So, Mr. Chairman, I urge my colleagues to oppose this amendment, and I yield back.
Gentleman yields back. Does the gentleman from Massachusetts, Mr. Lynch, is recognized for 5 minutes.
Thank you, Mr. Chairman. I do want to point out what also is happening here. This bill, by arbitrarily capping and penalizing the use of official time, interferes directly with the union's duty of fair representation to its employees. So, as we've heard, all of these amendments that would carve out cases where there's been sexual harassment or cases where there's been racial discrimination. We've tried to maintain the ability of the union to represent employees who are faced with those type of cases to no avail. So at some point the union will be unable to meet their duty, their obligation of fair representation to those employees. The other side of the coin is this, that when those employees raise those claims, and the company also, by refusing to allow official time, also dismisses and obstructs people from bringing those claims, while the claims against the union will be a failure of meeting their obligation of fair representation, for the company it will be a civil rights violation. So you're inviting the agency to have huge exposure to civil rights violations by dismissing or obstructing the claims being brought by their employees. This goes to the very heart of why we have a grievance procedure, so that people's rights won't be trampled and these claims won't be stifled. They'll be able to bring them forward. By putting penalties on the very act of bringing those claims forward and having them addressed by the employer and the union, you're inviting there'll be a floodgate of litigation against the agencies for stifling these claims, and there'll be civil rights violations, and against the union there'll be failure to provide or meet your duty of fair representation on the part of the employees. So this is a calamity. It really is. And I'm just trying to demonstrate and by debate reveal some of the pitfalls, the many pitfalls and frailties in this bill. With that, I'll yield back the balance of my time. Actually, I'll yield to Mr. Raskin if he would like some of my time.
Thank you very much, Mr. Lynch. And I would just take 2 minutes to add my voice in support of Mr. Cummings' amendment. This, again, does go to the heart of the deal that was struck back in the Civil Service Reform Act of 1978. As I understand it, the whole nature of the legislative bargain is that the union would represent non-union members in return for having this official time possibility as part of the collective bargaining agreement. And it makes sense, because if the union is going to have the duty of representing non-members, that is people who don't pay dues, free riders, then the union should not have to pay its own money to do that, that is, take fees from the dues-paying members, nor should the employees who agree to act as representatives for other employees in grievances and workplace conflicts have to do it on their own time in the nighttime or in the weekend. And so what we're doing is we're taking a very complex and delicate and time-tested balance that's built into the law, and we're bringing a sledgehammer to it in order to disrupt and to undermine the official time provisions. So I think that the Cummings Amendment is the very least we could do to restore some kind of balance to the law that's been so essential to the effective vindication of the rights of union members, non-union members, and then the employer's interest in having a harmonious and effective workplace. With that, I'd yield back to Mr. Lynch.
Gentleman yields back.
Thank you, Mr.
Any other member wish to speak on the Cummings amendment offered by Ms. Norton? If none, the question is now on the amendment, the Cummings amendment offered by the gentlewoman from the District of Columbia, Ms. Norton. All those in favor signify by saying aye.
Aye.
Those opposed, no. No.
Mr. Chairman, request a recorded vote.
A roll call vote has been requested. As previously announced, further proceedings on the question will be postponed. Does any other member wish to offer an amendment? Does any other member wish to strike the last word and be heard on the bill? If there are no further amendments, as roll call votes on amendments to the underlying bill have been requested and postponed as previously announced, the committee will now move to the next item on the agenda prior to voting on the passage of the underlying legislation. So, the next item for consideration is H.R. 1387, the SOAR Reauthorization Act, and the clerk will designate the bill.
H.R. 1387 to reauthorize the Scholarships for Opportunity and Results Act and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Without objection, so ordered. I'd now like to recognize myself for my statement on the legislation. Thank you very much. This H.R. 1387, the SOAR Act, will reauthorize and strengthen a successful and important program that is critical to helping district children achieve academic success, the Opportunity Scholarship Program. The Opportunity Scholarship Program, or OSP, awards scholarships to eligible district students so they can attend private school that might otherwise be beyond their parents' financial means. The District of Columbia's public school system has consistently had a host of numbers of challenges, and certainly the rankings near the bottom in terms of its performance. As one successful OSP graduate testified at a hearing this committee had in the 114th Congress, quote, "Every child should have a chance to receive quality education because at the end of the day, they are the future," end quote. I could not agree more. Providing every possible opportunity for students to receive the best education available ensures that the next generation is on a pathway to success. It is exactly why the SOAR Reauthorization Act is so desperately needed and what it will do. We know that SOAR is working. The Opportunity Scholarship Program has helped students at every type of school in the district achieve greater success. In the year 2014, we saw graduation rates for students participating in the OSP reach 89%. Let's say that again. Almost 9 out of 10 students participating in the program graduated from high school. On top of that, 92% of those graduates ended up enrolling in college or university. So SOAR is not just helping those who participate in the Opportunity Scholarship Program. We've seen great gains across all education sectors thanks to SOAR. In 2016, the D.C. public schools saw graduation rates of 69%. D.C.'s public charter schools also saw tremendous graduation rates, with the rates nearly 73% in 2016. From elected officials such as Mayor Bowser to the Washington Post editorial board, there is recognition that SOAR works for district students. I'd like to ask unanimous consent, and there's a long list here. I'd like to ask unanimous consent to enter the following letters of support, op-eds, and other statements, that these be entered into the record. Again, letters of support. These include the March 2016 letter from D.C. Mayor Bowser and various D.C. council members, the June 2009 letter and February 2011 letter from various D.C. council members, the April 2016 letter from the American Federation of Children, the April 2016 letter and March 2016 letter from the D.C. Catholic Conference, the December 2015 letter from D.C. Mayor Bowser and the Chairman of the Council, Mr. Phil Mendelson, The April 2016 letter from the National Coalition of Parental Choice, the April 2016 letter from the Chamber of Commerce in the United States of America, April 2016 letter from the Americans for Prosperity, April 2016 letter from the Family Research Council, April 2016 joint letter from the Committee on Catholic Education of the United States Conference of Catholic Bishops and the Archdiocese of Washington, April 2016 statement from the Thurgood Marshall College Fund, the March 2016 Washington Post article by the editorial board, and the December 2016 letter from the Friends of Choice of Urban Schools. Without objection, these will be entered into the record. They're also calling on Congress to reauthorize the program and make sure SOAR is available in the future. Last Congress, we managed to achieve an important aspect of making the Opportunity Scholarship Program successful in the future, releasing the carryover funds. I've already heard from groups on the positive impact of the carryover funds. More students in the district have access to high-quality education and a greater menu of education options. I know I speak for the parents of each of the students who will now receive a scholarship because the released funds, because of the released funds, in thanking my colleagues for passing the important legislation, but our work is not done. As it stands now, the SOAR Act and the Opportunity Scholarship Program's authorization has expired and must be renewed. The legislation will do just that by authorizing appropriations for the program through fiscal year 2022. That's why I urge my colleagues to vote in favor of the bill and help us make sure that a child who might be the next great success story has all the opportunities they can before them. I really do urge the passage of this. It's something we had done in the last Congress, but in this committee, and I urge that its passage in this Congress as well. And with that, I will yield back and now recognize Ms. Norton of the District of Columbia for her statement on the legislation.
Thank you very much, Mr. Chairman. Before I offer my remarks, could I make a parliamentary inquiry?
Yes.
Mr. Chairman, Congress has adjourned for the evening.
Yes.
I'm asking whether or not you expect votes tonight, the votes that were postponed, to be taken this evening.
I don't know if that's necessarily a parliamentary inquiry, but I assured the committee and all members that we would continue through all of these, for these two bills, the previous bill as well as the SOAR reauthorization. But we have also said that we would postpone and roll votes. That very well may be tomorrow, but I'm trying to find a time that would be appropriate and palatable to both sides and the maximum number of people.
Thank you for that clarification, Mr. Chairman. As a mother, I certainly have no criticism of parents who seize any and every educational opportunity that may be available to their children. I believe, and I think you will see by this statement, that my opposition shows that we mean no punitive effect on these children, because I believe that the current voucher students should remain covered by this program, this voucher program, until they graduate from high school. Now, this is a compromise offered by then-President Obama, but rejected by the Republicans. Republicans used to know how to compromise on bills and even vouchers. Then-Speaker Newt Gingrich wanted to create a voucher program in the District of Columbia when he was Speaker. I told him that D.C. already had a few charter schools and had a charter school procedure. And I worked with the Speaker. We worked together instead on legislation that created the present charter school system in the District of Columbia, which is considered the best in the country. The most interesting question today is why Republicans consider the D.C. voucher program necessary in light of such a strong charter school choice, alternative choice from the public schools. Since President Trump, Education Secretary DeVos, and the Republican leadership all strongly support vouchers, why is the Education Committee not marking up a voucher bill for the country as I speak today? The answer, of course, is that there is very limited support for private school vouchers in the Congress and in the nation. When Republicans cannot pass controversial national legislation, they instead abuse their power over a jurisdiction they view as defenseless. Republicans have controlled the House since 2011, but they have never brought a national voucher bill to the floor. Last Congress, during the reauthorization of the Elementary and Secondary Education Act, the House and Senate actually cast votes on several national voucher amendments, and each and every one of them failed. Moreover, Congress has never authorized the D.C. voucher program in the light of day. When Congress first created the program in 2004 and then reauthorized it in 2011, it did so by adding voucher bills as riders to appropriation bills because they couldn't get their own people to vote for private school vouchers. Unlike the House, the Senate has never passed a standalone D.C. voucher bill. Neither chamber wants to face its own constituents to explain why federal funds should go to private schools. A similar pattern played out just last month. This committee passed a bill to nullify the district's medical aid in dying bill, when other committees could have been marking up a bill to ban the procedure nationally. Republicans are not going to bring a national ban on medical aid in dying to the floor, however. 69% of Americans support that procedure. 24 House Republicans from 6 states where the procedure come from 6 states where the procedure is legal, and Republicans tried but failed to ban that procedure 20 years ago. Since the 1970s, the D.C. government has had authority to write a voucher program, but it has never done so. Yesterday, a majority of the D.C. Council sent a letter to the committee opposing admission of new students to the voucher program and requesting that any funding be given to D.C. public and charter schools instead. The 3-sector funding in the bill only exists because when the voucher program was created, I repeatedly pointed out that D.C. public and charter schools were the preferences of D.C. residents. And to his credit, the Archbishop of Washington asked Congress to also give funding to public and charter schools. It is clear that Republicans do not take into account the views of the D.C. government or its residents. In the first 2 months of this Congress, in addition to trying to nullify the district's medical aid in dying bill, this committee has launched an investigation of D.C.'s program to support immigrants. The House has also voted to permanently prohibit D.C. from spending its own local funds on abortion services for low-income women, the only jurisdiction treated this way in the United States. And a bill was introduced once again to eliminate all of D.C.'s gun laws. The D.C. voucher program has failed its central purpose. It has not improved academic achievement as measured by math and reading tests, and that ought to be the test. The program is therefore patently unnecessary. I doubt that the district of any member of this committee has a more robust public school choice program than D.C. has. Public school choice in D.C. Is offered to every single child. Almost 50% of public school students attend charter schools. 75% of public school students are allowed to go out of boundary to find schools they prefer outside of their own local neighborhood in order, by their measure, to improve their access to better education. I appreciate the bill makes one important improvement to the 2011 law. It requires voucher schools to be accredited. Isn't it amazing we're just getting to the point of accreditation? Remarkably, there were no accreditation requirements until Congress first imposed them in the fiscal year 2016 omnibus appropriation bill. I remain very concerned, however, that the bill does not prohibit schools that rely primarily on voucher students to exist. Those schools are known as voucher mills. From participating, they may participate in this program. It weakens the vigor of the evaluation of the program's effectiveness and does not provide voucher students with protection of civil rights laws. I want to reassure my own constituents that even if this bill is not enacted, which I believe is unlikely with Republicans controlling the executive and legislative branches, but even so, the Republican-led appropriation committees have always funded all three sectors, and they will probably do so again. I continue to believe, however, that federal funding for education in the district should reinforce the hard work of our city, our parents, and our residents who have shown the nation how to build a fully accountable public choice system. I thank you very much, Mr. Chairman, and yield back.
Thank the gentlewoman. Does any other member wish to be heard? Yeah. Does any member wish to strike the last word to be heard on the bill? You can offer an amendment, but if you want to be heard on the bill prior to...
Thank you, Mr.
Mr. Conley, did you want to?
I have an amendment, Mr. Chairman, if you want me to wait.
Are you okay if we
Yeah,
move
sure.
to strike the... Okay,
Yeah.
let's go to Mr. Raskin is now recognized from Maryland for 5 minutes.
Mr. Chairman, move to strike the last word. Thank you very much for recognizing me. I want to associate myself very strongly with the remarks of our distinguished colleague representing the District of Columbia. It seems clear to me after several months in Congress now that there is an ideological offensive against public things. There's an attempt to defund and strip public schools and put money into private education. There's an effort to sell off public lands and public properties. There's an attempt to dismantle public regulation affecting clean air, clean water, and other public goods. There's been a freeze put on federal public employment and continuing moves to privatize and outsource. And now the good people of the District of Columbia, some 700,000 tax-paying, draftable American citizens, are subject to legislation that they don't want. The federal government presents itself saying, the federal government is here, and we're here to help you. And somehow the people in the District of Columbia are taking it with a grain of salt, because who's closer to the public schools and public education in D.C. than the D.C. Board of Education, the members of the D.C. Council, and the people of the District of Columbia who are not asking for this legislation which is being imposed upon them. Representative Norton
Will the gentleman yield?
Yes.
I mean, one of the letters I entered into the record was from the mayor supporting and asking for this.
Mr. Chairman, I appreciate that. I understand there's a letter from a majority or a supermajority of the D.C. Council continuing to oppose the legislation, and I know that's a political fight that happens in lots of jurisdictions, but if you had a conflict between the state legislature in Utah and the governor, you would not have a law because the state legislature would not have adopted it. So I think the D.C. Council has not approved this as a legislative enactment, and they are the representatives of the will of the people. And it's a point that I think we like to insist upon, Mr. Chairman, that Article 1 makes Congress the lawmaking branch. The legislative branch expresses the will of the people. The executive, whether it's a president, a governor, or a mayor, implements the laws that are adopted by the people in service of the public interest. So, but look, we don't need to be pulled into intramural food fights in the District of Columbia or in any other jurisdiction. We just have to allow them to govern themselves. And lots of kids in D.C. go to charter schools, and the charter school experiment seems to be working, along with other improvements that have been made in the D.C. public school system. So I will be voting with my friend Representative Norton in the interest of democratic self-determination of the people of our capital city. And with that, I would yield back, Mr. Chair.
Gentleman yields back.
Mr. Chairman.
We now recognize the gentlewoman from North Carolina, Ms. Fox.
Thank you. I move to strike the last word.
Gentlewoman's recognized for 5 minutes.
Thank you, Mr. Chairman. I want to say I am not opposed to public things. I think all Republicans know that we need a certain amount of government. We do not want anarchy in our country. And many public functions have worked very well. I'm a product of public schools, both at the elementary and secondary level and at the higher education level. So I'm certainly not opposed to public schools or many other, again, functions that are run by our various governments. So I think it's important to get that on the record because I don't agree with my colleague on that. But I think that the SOAR Act and the Opportunity Scholarship programs the program has been very, very successful in the District of Columbia. And I don't see it as imposing on the people. It's providing a choice for people. And my colleagues on the other side of the aisle are very keen on providing choice when it comes to human life. And I think we should want more choice when it comes to people being able to choose a great public education. This is not, again, anti-public. The public schools saw an increase in graduation rates of 6% in 2014, 2015. But OSP students and charter students have achieved graduation rates of 90 and 70%, respectively. Statistics show that those with a high school diploma do markedly better in terms of median wages than those without a diploma. And there's also evidence that the unemployment rate for those without diplomas is greater than those with a diploma. And as the chairman said, the mayor of D.C. supports reauthorizing SOAR. She certainly represents the entire city, I believe. And SOAR does not take money away from the public schools in the district. Instead, it provides equal funding for public schools, public charter schools, and the Opportunity Scholarship Program. The OSP program also helps achieve greater graduation rates for students when compared to public schools in the district. 92% for OSP graduates compared to 64% for district public schools. We want all children to get a great education, and I cannot understand why anyone would be opposed to a program that has so well proven itself, particularly when it's helping so many minority students. You know, I take the stand that when any students anywhere are cheated out of a great education, we're all cheated, because all of the children and what happens to them in education impacts the entire country. So I think this reauthorization will strengthen the programs further and ensure it continues to achieve success for students. So I endorse it wholeheartedly, Mr. Chairman, and yield back the balance of my time.
Will the gentlewoman yield to me first,
I would
please?
be happy to yield to the chairman.
Thank you. As we talk about this, I really feel like this is more of a parental choice bill than anything else. It's interesting because there is a bit of a rift between the mayor and certain members of the city council. What we're doing today is authorizing the expenditure, authorizing this program so that when we go through the appropriations process, money can be appropriated. Now, once the money is appropriated for this program, then we'll see what kind of beer muscles the city council has, because they don't have to accept the money, right? They don't have to take the money. And then, but if they do take that money, you still have further choice, because the choice will be upon the parents or the students as to whether or not they apply and want to exercise this scholarship. So I think you're going to see a great deal of people who have gone through the program, had success. That's why people are lining up, wanting to do it, taking advantage of the program, and seeing amazing statistical success well above and beyond the other forms of education in the city. And it gives great hope to a good number of people, and I think it is the responsible thing for us to do to pass this piece of legislation. Last thing I would simply mention is I do want to thank our former Speaker Boehner, who poured his heart and soul into this and believed in it passionately. We wouldn't, I believe, be in this position to reauthorize something without the leadership of Speaker Boehner, who believes so wholeheartedly in this and has helped so many students and families along the way, and I just wanted to recognize him. The gentlewoman's time has expired, and she will be yielding back. The gentleman from Virginia, Mr. Conley, is recognized for 5 minutes.
I thank the chair, and I have an amendment at the desk.
Clerk will designate the amendment.
Chairman, before that amendment, could I offer a correction? The money for D.C. vouchers does not go to D.C., it goes to the Department of Education. So the council could not reject the money.
That objection, so that will be entered into the record.
Thank you, Mr.
Appreciate
Chairman.
that. Thank you. Very helpful. The clerk will designate the amendment.
Amendment to H.R. 1387, offered by Mr. Conley of Virginia.
Without objection, the amendment is considered read, and the gentleman from Virginia is recognized for 5 minutes to explain his amendment.
I thank the chair. I would just say, listening to my friend from North Carolina, Ms. Fox, whom I respect, she cited the fact that the mayor of the city represents the whole city because she's elected citywide. I would point out to my friend, Ms. Fox, that so is the chairman of the D.C. Council, Mr. Mendelson. He's elected at large by the entire city. He disagrees with the other at-large elected official. So we have a difference of opinion about this matter. No one individual represents the whole city in this matter. We have conflict. I just point that out for the record. Mr. Chairman, my amendment is designed simply to restore the original language in the original authorization with respect to evaluation.
Will the gentleman yield for just a moment?
Yes, sir.
Mayor Bowser and Mr. Mendelson signed the letter asking for reauthorization. Just to clarify.
Yes. But
he was not on the other side of the mayor on this particular issue, on the same side as the mayor.
yes.
Thank you.
My amendment is designed to restore the original language with respect to evaluation. Let's take a look at the original language in the statute. The original language said, the Secretary, through a grant, contract, or cooperative agreement, shall ensure that the evaluation under paragraph 1A is conducted using the strongest possible research design for determining the effectiveness of the Opportunity Scholarship Program under this division. In the text in front of us, that's amended so that it says, the Secretary, through a grant, contract, or cooperative agreement, shall ensure that the evaluation under paragraph 1A is conducted using an acceptable quasi-experimental research design for determining the effectiveness of the Opportunity Scholarship Program under this division that does not use a control study group consisting of students who applied for but did not receive opportunity scholarships. Which of the two sounds more rigorous? Strongest possible research design or quasi-experimental research design? One can't help but draw the conclusion that the evaluation standard has been diluted, maybe for a reason, because the metrics produced by the tougher evaluation standard doesn't always comport with the assertions about the merits of the bill itself. So I think that this would be strengthened if we had the more rigorous of the two evaluation standards, and my amendment would restore the original evaluation language in this bill. With that, I would, is my friend from D.C. seeking? Yeah, I would yield the balance of my time to the gentlewoman from D.C.
I thank my good friend for his support and for yielding. And since we've been discussing the mayor's support, the only thing we have in writing says, from the mayor, says, our support for the SOAR Act is rooted in the importance we place on the much-needed federal funding for the D.C. public schools and public charter schools, which total $30 million. The mayor obviously thought she had no choice but to accept the money for vouchers because she'd lose the money, two-thirds of the money altogether. In respect to this amendment, why we want to weaken evaluation? We're subjecting our public and charter schools, just passed the Elementary and Secondary Act last Congress, to greater rigor. But we are reducing the rigor of that we associated from the very beginning with these schools. The entire reason given by my Republican colleagues for this bill is they wanted these children to have access to better education than the D.C. public schools. But now they want to weaken their evaluation of whether or not that is happening. That is why my good friend from Virginia wants to strengthen the evaluation, is in keeping with the original purpose of the bill in the first place, and I thank him very much.
Reclaiming my time, and I thank my friend. The chairman and I, in a sense, are both right and both wrong with respect to Mr. Mendelson. Mr. Mendelson signed the letter with the mayor last year in favor of the reauthorization. He did not sign the letter this year. Neither did he come out in opposition to the reauthorization. He's been silent, apparently, about it. But we did receive a letter from 8 members of the D.C. Council, as I understand it, opposing reauthorization. So I stand corrected, and maybe, Mr. Chairman, gently I suggest you as well.
If the gentleman will yield, both letters have been entered into the record. Mr. Mendelson and Mariel Bowser, as well as other members of the council at the time, did send us a letter in support. Then there are some letters that came in yesterday, in opposition. And let's make sure that that's been entered into the record as well.
I thank the chair.
Without objections ordered, y'all can read what your council member did or didn't do and figure out for yourself what you'd like to do. Anyway, so the gentleman yields back, right? All right. I will now recognize myself in opposition to the amendment offered by Mr. Conley. The amendment stands in direct contradiction to the opening up of the OSB scholarships to students who previously participated in the control group for the study. The study required by this amendment would require that a participants be excluded from a chance at receiving scholarships in order to establish a control group necessary for the strongest possible research design. The evaluation process was carefully and meticulously debated and considered to ensure that students are not unnecessarily excluded from the academic opportunities provided by the OSP. The evaluation standards included in SOAR will require that the evaluation be done to the highest possible standards while still allowing all eligible students to participate. The amendment is therefore, I believe, unnecessary, would only serve to exclude students from the participation in the OSP, and I stand in opposition of the amendment. Does any other member wish to be heard on the amendment? We're still dealing with Mr. Conley's amendment, so. Does any other member wish to be heard on the Conley amendment?
It's not the right thing. It's not going to be the strongest.
If none, the question is now on the amendment offered by the gentleman from Virginia, Mr. Conley. All those in favor signify by saying aye.
Aye.
Those opposed, no. No. In the opinion of the chair, a roll call vote has been requested. As previously announced, further proceedings on the question will be postponed.
You anticipated. All right.
Thank you. Speeding up the process. I believe Ms. Watson-Coleman. Ms. Watson-Coleman has an amendment at the desk. The clerk will designate the amendment.
Amendment to H.R. 1387, offered by Ms. Watson-Coleman of New Jersey.
Without objection, the amendment is considered read, and the gentlewoman from New Jersey is recognized for 5 minutes to explain her amendment.
Thank you. Thank you, Mr. Chairman. This amendment reflects a simple idea. Federal funds should not be used for discrimination. Currently, schools receiving voucher money are prevented from discriminating against students based on race, color, national origin, religion, or sex. My amendment would add sexual orientation and gender identity to this list. This committee is clearly divided on the merits of private school vouchers, but to those who believe vouchers are necessary to provide opportunities to students in struggling schools, surely we must require that those opportunities be available to all students. Yet under current law, LGBT students can be denied admission, expelled, or otherwise treated negatively just because of their sexual orientation or gender identity. For a federally funded program, that is unacceptable. LGBT youth are particularly likely to be bullied or physically assaulted at school, making it essential that we ensure this vulnerable population is protected from discrimination. This amendment would simply give them the same protections we give other students participating in the DC voucher program. Some of my colleagues may have concerns about interfering with private institutions, but these schools make a choice to participate in the DC voucher program. If they don't want to abide by non-discrimination principles, they are free to not accept federal money. I find it entirely reasonable to expect schools that accept taxpayer dollars, including from the LGBT BGT taxpayers in all of our districts, to spend that money in a non-discriminatory way. Just earlier this year, President Trump announced he will keep in place President Obama's executive order prohibiting federal contractors from discriminating against employees on the basis of sexual orientation or gender identity. This decision reflects a growing bipartisan consensus that those who choose to accept federal money should not use those funds to discriminate. I therefore urge my colleagues on both sides of the aisle to join me in applying this logic to the DC voucher program by supporting this amendment. And I yield back, Mr. Chairman.
Gentlewoman yields back. We now recognize the gentleman from Alabama, Mr. Palmer, for 5 minutes.
Mr. Chairman, I speak in opposition to the amendment. What we're trying to do here is give students the best chance for a quality education, and this amendment really doesn't address that. It introduces unnecessary controversy into a bill designed to help children achieve academic success. It's an issue that's already enmeshed in litigation and was only just recently remanded by the Supreme Court. And the District of Columbia already prohibits discrimination in public educational institutions based on gender, sexual orientation, and its Human Rights Act. So since SOAR is applicable only to the district, including this as a protected class is unnecessary, and I encourage the members of the committee to vote in opposition. I yield back.
Gentleman yields back. Does any other member wish to speak on the Watson-Coleman amendment? Gentlewoman from the District of Columbia, Ms. Norton, is recognized for 5 minutes.
Thank you, Mr. Chairman. I do want to point out that the voucher program has a meaningless non-discrimination provision. You know it's meaningless because otherwise you wouldn't have language that exempts these charter schools from the federal civil rights laws. They don't define it. And what is particularly heartless is that even this meaningless, undefined non-discrimination provision does not exclude disability. So disability students who happen to choose a voucher school would not be protected in any fashion. So it's glaring that the protections that are available in public schools and in charter schools are without any meaning, and we just as well take this non-discrimination provision at a time when we've learned what discrimination really means in our society out of the bill, and I thank you and yield back.
Gentlewoman yields back. Does any other member wish to speak on the Watson-Coleman amendment?
Mr. Chairman.
Sorry, who said?
On your left.
Oh, Ms. Fox. I kept looking over there, so I'm glad to have somebody. Ms. Fox is recognized for 5 minutes.
I won't take very long, and I know that Ms. Norton is much more familiar with what happens in the District of Columbia than I am, but I would point out that while she may perceive a weak non-discrimination clause in the SOAR Act, the district, as my colleague from Alabama pointed out, the District of Columbia prohibits discrimination at public educational institutions based on gender and sexual orientation in its Human Rights Act, and because SOAR is applicable only to the district, including these as protected classes is unnecessary.
Will the gentlewoman yield?
I will.
Your very words were public. These are private schools. So the district law does not cover private schools.
Thank you, Mr. Chairman. I yield back.
Does any other member wish to speak on the Watson-Coleman amendment?
Mr. Chairman.
Gentleman from Maryland, Mr. Raskin.
Thank you very much.
For 5 minutes.
And this is only to follow up on Representative Norton's point. We're invited to reject what I think is a perfectly common sense and appropriate amendment extending the non-discrimination principle to schools that are going to be getting federal funds. And we're invited to reject it on the theory that it's District of Columbia policy already to forbid discrimination on the basis of sexual orientation and gender identity. Well, if this is meant to assist the District of Columbia, and it's the policy of the District of Columbia to foreclose these kinds of discrimination, why would we not include it in this legislation to assist the District of Columbia? And if we just want to assist children in the District of Columbia or the lucky few who get to have these scholarships, why shouldn't that group include those who identify as LGBT? In other words, if we want to override basic principles of democracy to intrude and to micromanage the educational affairs of one jurisdiction, of all the jurisdictions in the country, in order to help kids, in our view, why wouldn't we want to help all of the kids? I salute the Congresswoman for introducing this amendment, and I think this really does put us to the test. Do we mean what we say? Will we respect the policy of the District of Columbia with respect to non-discrimination? And will we actually try to assist all of the young people in D.C. Who might, want a chance to win one of the golden tickets? With that, I yield back, Mr. Chairman.
Gentleman yields back. Does any other member wish to speak on the Watson-Coleman amendment? If none, the question is now on the amendment offered by the gentlewoman from New Jersey, Ms. Watson-Coleman. All those in favor signify by saying aye. Aye. Those opposed, no. No. We will have a roll call on this vote. As previously announced, further proceedings on the question will be postponed. Mr. DeSaulnier.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will designate the amendment offered by the gentleman from California, Mr. DeSaulnier.
Amendment to H.R. 1387 from Mr. DeSaulnier of California.
Without objection, the amendment is considered as read, and the gentleman from California is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This will not be inconsistent with the previous conversation. My amendment ensures that schools receiving funds authorized in this bill adequately protect students with disabilities. As you know, the Individuals with Disabilities Education Act, or IDEA, was originally enacted in 1975 to ensure that children with disabilities receive the services and accommodations they need to be successful in school. For the past 42 years, IDEA has governed how states and public agencies provide early intervention, special education, and related services.